Hey everybody, I'm attorney Kyle Kaufman at hkklawoffices.com. In today's video, I am going to talk about modification of child custody. Before I do that though, if you like this channel, please give us a thumbs up, subscribe to our page, leave comments, questions below. We want to make more videos for you. So I'm an attorney here in Wisconsin, right? And we practice family law. We get questions all the time about how to modify child custody. People will say, do I have a case? All right. So modification of child custody, what people are really talking about is modifying the placement schedule. That's the amount of time that each child spends with the other parent or with you. And we're working off the premise when you're modifying child custody that there is already a judgment in place, right? There's been a judgment made as part of a divorce or a paternity action that says specifically this is the amount of time that this child or children spends with one parent versus the other, all right? Now, when can you go back and modify that? See, the courts don't want people coming to court every other week or every month or even every year to say now it's time for a change. But the thing about kids is that their lives do change, right? There's a big difference between a 2-year-old and a 12-year-old and what that child's needs are, their education, perhaps there's been different things that have come up in their lives. So what we're really looking at is a time period and judging whether or not there's been a substantial change in circumstance, okay? A substantial change in circumstance could be one of many things. It could be age, but age alone is probably not going to be enough. It may be educational needs, it might be emotional needs. Perhaps something has happened with one of the parents that's causing a need to change child custody. Unfortunately, we do have situations like drug abuse, alcoholism, even domestic abuse could be a qualifier for a change in child custody, all right? Now, that is a substantial change. Now, there's another concept in Wisconsin that within 2 years of a final judgment after a divorce, for example, or the first paternity judgment, if one parent can prove that the current conditions are emotionally or physically harmful to a child, that may qualify, or if they can prove, it will qualify, that that person can have a review of the schedule and to see if changes should be made. So those are the real significant, severe safety issues, right? Emotional or physical abuse that we're talking about where somebody could get into court sooner than later. But for most cases, we're talking about a time period has gone by and there's been some substantial change. And it's at that point that we see most people filing motions asking to review the placement schedule, okay? Some other examples that could be a substantial change could be somebody moving, could be a new home, maybe one of the parents has remarried, maybe there's new step siblings in a home or something of that nature. So there's lots of things that can happen. The best thing for you to do if you're watching this is in your state is to go and consult with an attorney. I recommend that you talk to at least 3, okay? And go to get a good opinion from each one of them and choose the attorney that you trust to best handle your situation. What I tell my clients is the courts don't care unless you care. So make sure that you have a really valid reason for wanting to change custody and modify it. And make sure that you're expressing that to your attorney so your attorney can then help you in court and win your case. All right, guys, if you have any questions about child custody and modification of that, leave those questions below, comments below. Be happy to answer them or make another video for you. We'll see you next time. Thanks.